Y'all come in, 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 beautiful people, real deals. Y'all play too much. Y'all come in, real deal, come in, real deal, come in, real deal. Okay, come in. We want to go ahead on and get started. I know y'all gonna come in, and my fault for not putting out a notification. I will do my duty and do my best to start putting out a notification for you all. I want to go ahead on and get started. Y'all just come on in where you fit in at, okay? Uh, we want to start on day 53, strictly witnesses. That's what this about. It's not a testimony today with the Yanta Rico trial. It's not a testimony today. The only thing that the state and the defendant and the judge is speaking on, uh, what they are not going to do next week in front of the jury. Okay, so in other words, just saying to them, have your stuff, have your paperwork together, have your witnesses together, have your videos together. Uh, that's what they're saying. So let's look at this.
Jury is not present today.
The board's looking so nice.
Every Medicare recipient over 65 years old needs
Each
to see
one of
this.
the guys,
The
each
government
one of
just gave
those
me
boys,
thousands of dollars on a new.
each one of those young men
Um,
is looking
just
real
a way
good.
of housekeeping before we get to the main
Sitting with
matter
their
at hand.
attorneys.
I received an email from Ms. Love, two emails this morning. First one was regard to the witness list that we're going to talk about in just a minute, along with an email, which I'll mark as the next court's exhibit in order, which references a YouTube link and may be used later to in the current examination of Miss Archellen Bennett. I'll mark that as the next court's exhibit. And then also the next court's exhibit will also be another email that's sent by Ms. Love to all of you at 11:25. Well, that's the last night, I should say. I'm sorry. At 11:25 p.m. Which
Excuse me, y'all. What I'm trying to do is work with my camera right now. Hold on for a minute. I'm not in the office. I'm not in the YouTube office right now, okay? No, I'm not. I ain't trying to flex though. I'm in this. All right. House of the Falcons, y'all. Okay. Let's see how the camera gonna work now.
references or summarizes the conversation she had involving Miss
I got too much light.
Angela White. Okay, so that's marked as next course exhibit in order. All right, and then so to the matter at hand this morning, the state's witness list. So how many witnesses do you have on this current list? And it is enumerated from pages 1 through 12. I'll make that as the next court's exhibit in order for the purposes of our discussions.
Your Honor, inclusive of two names that were erroneously numbered twice, there are 209 persons on that list. There were a few persons who were added as a result of testimony that has come about over the past week regarding witness statements made in the presence of investigators and other personnel with the district attorney's office that we have
Let me turn it up.
We had no intention initially of calling our case in chief with the exception of anyone who's previously been listed on the witness list prior to now. For instance, Chief Investigator Randolph has already testified. We did not intend to call him back, except that the witness has made.
The witness, whom are you referring to in
Ms.
terms
Bennett.
of the witness? All right, Ms. Bennett, okay.
She made statements to me. Ms. Bennett made statements in the presence of not only myself, I was never by myself when I spoke with her. So the persons who are listed that are somewhat new, Ms. Dos Reyes, I asked Ms. Bennett about the tall advocate with curly hair that spoke with her when she indicated that she did not wish to speak with me outside in the hallway. Lieutenant Baker, Hamilton, Randolph, and victim witness advocate Kelly are all persons that.
What's Miss Kelly's first name?
Tamika, Tameka. She's number 63. They are all listed. Those people that I just named are all listed on page 3 of the list that we have provided to your honor and to counsel for the defendants. And they are after crime scene technician Montgomery Porter.
Okay, so the first 56 you have on this list are witnesses we called already.
Yes,
I know we're still examining Miss Bennett and Mr. I should say the retired Detective Quinn.
yes.
So what's your net number of witnesses that you are planning to call?
That are remaining.
That remain, yes, ma'am.
209.
I think she said 106.
153.
153 witnesses. Good Lord.
And this 153 witnesses, you still believe and contend it's going to take 120 trial days?
Judge, what we did on our list is we gave a gross estimation based on the length of time that we have had to tape with certain witnesses, factoring in both state's direct, anticipated cross, and averaging out the way that certain witnesses such as Mr. Stevens, Ms. Bennett, Mr. Bean have gone in the length of time that they've taken, and applying that, overlaying that analysis
But you the one did that.
over other similarly situated persons. Our very, very, very rough estimate.
It was you.
Can we shut the door back there if you wouldn't mind, please?
I apologize, Your Honor, I didn't.
No, can we shut the door behind you? There's sound was carrying, that's all.
That was the state asking the witnesses of all those questions, not the defendant.
Factoring in the,
All right, so, yeah, for example, so for Acts 5 through 7, if I'm reading your time correctly, you're saying it's going to take us from April the 8th to April the 10th.
yes, that's
Okay.
exactly how we've listed.
And that's your gross estimate. All right.
Yes.
Okay.
153 witnesses.
Then the next series of witnesses from April 9th to April the 11th,
Yes,
and then so on.
yes.
Okay. All right.
Y'all ain't gonna do right. state is not gonna do right. It's their way or no way.
And the longest ones, the court will notice, are 2 homicides that are on the list on our indictment. Those are the acts that we anticipate will take the longest amount of time to.
Okay. Has all of the discovery been tendered in respect to these acts that you are
Claim.
you're proposing on these particular days? And I understand these are gross estimations of how long it will take. So,
And I apologize, Your Honor, I did not hear the court's full question.
my thought was not complete. So, have you turned over or tendered to make sure that the discovery that matches these particular witnesses has been turned over already?
Yes, Judge, we
You scrubbed that again, and have you met with defense counsel, or
No.
are you assured that that all of the documents that are turned over have been turned over that are responsive to these witnesses? And what I'm asking is so that when a witness is called, and like I said before, if we have a situation where that document has not been tendered, or you can't tell me when it was given to the defense, if you tell me we gave it to the defense on February 15th and it's in the same form, and they tell me, well, we haven't seen this, well, then we're just going to go forward. But if not, like I said, that's when I'm going to exercise several other options. So, are you sure of that? Are you sure that you've tendered everything?
No.
I'm fairly certain, and Judge, what we've been doing is prior to each of the acts, what we've been doing is sending over our exhibit list along with the witnesses that we intend to call for the upcoming weeks. So we will continue to do that. And if there was an oversight, error, or omission, not with respect to turning it over, but with respect to just alerting defense, we'll be using this exhibit in this act or with this witness, that I believe should cure any concern with respect to those issues. Because I believe that's what we have continued, that's what we've done, and that's what we'll continue to do.
The challenge that we
No. That's not what y'all been doing. What the state been doing is on them, the witnesses and their reports at the time in front of the jury. Now watch the judge gonna bring this up. And he about to change things, y'all.
had is that defense counsel either says that they have not received that.
That's right.
Okay. Or it's an augmentation of something you gave them. So, for
That's
example,
right.
the discovery you gave them may have had 15 pages. Now it has 25. It's more complete. Or, as I mentioned a couple of days, yesterday, that you found something the night before from an Instagram search or whatever else of a particular witness, and you wish to use that. So that's what kind of, and then with the defendants, if you're going to, you need to be able to kind of state with particularity of what the state has not given you, or I'm going to start asking why it hasn't been reduced to writing. Because the older or the more you've had the particular evidence, or the discovery, I should say, the more I'm probably just going to go forward. So certainly subject to, of course, exceptions.
You know what? I don't have nothing against Miss Love. She's doing a great job. They need to stop disrespecting and interrupting the judge when he speaks. I think they need to respect the judge more. She always cut him off. And maybe he's going to say what she thinks he's going to say. But disrespecting the judge, I don't agree with that at all.
For instance, reducing prosecutors' conversations with witnesses to writing or?
No, ma'am. No. I'm saying, what I'm finding is, like, for example, last week we had some telephone calls that I had to go through with you all that Mr. Steele brought up.
The text message?
Some, in terms of, I think it was Mr. Bean. At the universe of maybe about, you all had told me you have hundreds and hundreds of calls, but relative to this particular period, you had about 10 calls that were relative to the inquiry at hand.
Right.
Well, 2 of them hadn't been gone through already, and I had to take up those in front, while the jury was sitting in the box. I'm not going to do that again. So what I'm saying to you is, if you haven't turned all those over, or the defense hasn't filed a motion in respect to that, we're going to go forward.
Your Honor, what we had done with those 10 calls, as the court, I'm sure, is aware at this point, we had turned over the 10 calls. We had spoken with defense about which ones we intended to use. We had, before December, we had identified, and Ms. Hilton was able to actually locate the email wherein she told the defendants that we are using all of these jail calls right here.
Okay, but there were objections as to those jail calls, and I can't take those up while the jury's sitting in the box.
Right.
And that's what I'm saying to
That's
you.
what he's saying.
My remedy is going to start being to exclude those calls, because I'm just not going to have, because we've had sufficient time to do that. So unless somebody files a motion or puts me on notice, remember I told you, happy judge, forewarned judge, happy judge, because then I don't have to take it up and have our jurors wait. I mean, and I'm not saying in any way I'm trying to limit your ability to present to either side, but what I am going to start kind of enforcing, pretty draconian in measure, will be if you all don't forecast the problems or issues you're going to have, then I'm just going to exclude it. Because I think that we've gone far enough down the road that you all are seasoned enough advocates. So if for example, you're going to use 5 calls and the defense either has told you, hey, if they don't bring up something and they bring it up at the last minute, my remedy is to exclude it.
Your Honor, the problem is that we had, with those 10 calls, not only served them, not only announced that we were playing them, not only announced that we were playing all of them, but we had repeatedly asked from the defense, what portions do you object to? So we had satisfied all of our statutory obligations. We had even satisfied beyond that, because we repeatedly requested of counsel for the defendants, which parts do you object to? And it was not until, and in fact, a motion in limine was filed as to one, but it was not until we tendered the calls that we had previously provided that the objection was made. So, Your Honor, we would of course object to exclusion of evidence.
I'm going to want to see that you had the I'm sorry. Let me let you finish. I'm going to go ahead and of course, it's subject to the reasonable test, meaning that if you sent the defense had conversations with them about it and nothing happened, well, then I'm not taking it up.
Hey, you! Stop what you're watching right
See,
now.
I know what she's saying. I understand what she's saying.
If it wasn't dealt with, because somebody, like I said, I'm in no way saying don't try your case or don't bring challenges up to me so I can resolve them. I'm just kind of at a point right now where it's like, look, I can't keep taking it up in front of the jury. I got to be able to kind of deal with it in a more timely manner. Both sides have
They
to
wasting
allow me to do
time.
that. It's just not fair. It's not fair
right.
to this jury. We're going to have them here till well into 26 if we don't do that. So you can see my soon frustration in the sense that you all know what's coming up. Both sides. I'm going to add. I said, look. I mean, we can take a down day or whatever else and resolve some issues. That's fine, but that's kind of where I stand at this point in time. So do you understand what I'm referring to, Ms. Love? Okay, all right.
And we will continue and we will copy the court so that there's no question, there's no doubt about what we have provided when we are providing it, when we are announcing that we will be utilizing it. We will continue providing in advance of putting the information before the tendering the information, the exhibits that we intend to utilize with the particular witnesses, and we will inquire whether there are objections. We will do that so that it is announced to not only the court and counsel for the defendants, but so that the court is aware that there is no matter that we will be putting before them for the very first time when we do it with the witness, so that the court would not be automatically inclined to think it's something that they haven't seen. We have had instances where we've been informed that certain discovery was not had by counsel for one or more defendants, and we've had to go all the way back to June of 2022 in the first discovery that was served to show where it was. So we have had instances of those type of things happening, but beyond having found something very recently, we have not introduced or tendered anything that we have not previously provided to the defendants. The court made us very aware that we had obligations that we were to fulfill by certain deadlines, and we adhere to those, and we will continue to adhere to the court's directive. But there are none of, I don't believe that the delays that have been that have come up during the course of the presentation of the state's case have had anything to do with the state.
There's, like I told you yesterday, Ms. Love, there's blame to go around on everybody, okay? I'm just, and that's why I didn't really need any argument yesterday. I really didn't, because I've sat here. So,
She like to argue.
I'm not casting aspersions on everybody. Like I said, I want everybody to do better. And if you don't do better, I'm telling you, I got 5 remedies, okay? So, and you heard the remedies yesterday. I'm gonna put them in administrative order. But I'm telling you.
He tired of y'all.
Right now,
He tired of it.
not enacted for
Me too.
to be punitive or draconian to anybody. But I have the right and manner and obligation to control this trial.
That's right.
And right now, it's not going smoothly.
It's not.
So,
See how they cut him off?
The state just made a representation that when they provided us the witness list, this is court ordered previously, that along with that witness list, they've been providing us with a list of exhibits. That's false. In the short time since that was stated about 10 minutes ago, I went back and looked at the witness lists that we were given on January 7th, February 9th, February 16th, February 23rd, February 25th, March 15th, and March 25th.
Get on him, boo.
While we were provided that list of witnesses as ordered by the court, and I believe that the state was following the court's orders, those witness lists did not include lists of exhibits. Since she has made that representation, I would love to see that going forward. If we could get a list of the exhibits that they plan on presenting
Ahead of time.
which witnesses are using those with, I think that would certainly make this a more efficient process, John.
Your Honor, if Mr. Weinstein was looking only in the emails with the list and not in other emails, he may have overlooked what the state has provided, but I am quite certain that we have provided in advance of our showing or tendering these exhibits, we have provided them to counsel for the defendants, and I can go through our emails and find those emails where we've done that.
That's great, Your Honor. If that's the case, I'm more than happy to hear it, and I would look forward to that going forward as well. And maybe if those were coupled with when we received the witness list, we could get a spreadsheet with that list along with the exhibits that are going along with the witnesses. We could look at those exhibits in advance and maybe be better prepared to make this a more streamlined process. And
Your Honor, we have provided more spreadsheets than we could ever hope to get. And Your Honor, we don't intend to catalog our list. We did that initially with the acts that we intended to present, the witnesses that we intended to present per act. when we provided the witness information. I'm certain counsel has resources available to do that for them, but we do not intend to do any more cataloging for the defendants.
I'm not asking them to do any more than they've already represented. If you go back and look at the transcript from today, you will see that the state has said that when they provide those witness lists, they also provide a list of the exhibits that the witnesses.
You
will
did say that,
testify
Ms.
to.
Love.
He-
And I mean that, Your Honor, but I do not intend to go and provide spreadsheets. We will do it as we have been doing, which is providing emails that contain.
Oh, she gonna tell the judge what she ain't gonna do.
Emails that contain the exhibits that we intend to introduce.
What?
Why can't you do both? Why can't you just make it simple? I mean, at this point in
Because
time,
Judge, it's just that we have no problem providing what we are intending to present. We've done that and will continue to do it. But Judge, this idea that we are the legal assistance and personal assistance of counsels for the defendants
saying-
who are
they're
required
not
to
saying- they're
put
not
this
saying-
in a
Come on, Miss.
spreadsheet.
That's
they're not saying that, man.
hold up, y'all. See, okay. I don't know why she's so difficult. Only thing he said, put it on a spreadsheet. Easy. You're not gonna tell the judge. I know she's not gonna sit there and act like she the judge. Or we gonna do it the way we've been doing it. No, he just said that just make sure that they have it. I mean, what's the problem? I believe what it is. She's probably doing other cases, and it's kind of slowing her up for doing her own RICO case. Maybe they need to replace her for somebody else.
Yeah, but the problem we're having is that you are identifying, or you're not, I'm sorry, whether or not you are or not, but I'm gonna deal with that in just a second. The problem is that you may think that you identified some evidence, you haven't. That evidence is about to be tendered, or they're looking at it and they're like, well, this is the first we've seen of this. And well, that's what they're alleging, Ms. Love. I'm not saying that's true, okay? But that's what they're saying. And they're telling you, or Mr. Weinstein's telling you, if you marry the act of the witness and the evidence you plan on using, because at this point in time, like I said, there's no surprise. Your elected district attorney tried a gazillion cases in front of me. She turned over an entire file to the defendant. And her mantra was, if you can beat me with my file, then you deserve to win. I deserve to lose. At this point in time, turn over everything. There should be no.
That's right.
No surprises at this point in time with
And to be honest with you all, the judge has mentioned this before. Give the people what they need.
Identifying evidence and everything else that goes along with it. So what I'm going to do is two things. I want you to catalog these particular. I want you to, for each act and ban that you're going to present, I'd like you to add the evidence you're going to call. I want you to, because here's the thing. What will happen is, one, objection, they can put it in writing or they can file it early and I can go ahead and do with it, like I said. And if they don't, or you say, they say, we didn't give that to you. We provided that particular document to you in discovery on March the 15th. So you should have it already.
That's
At
right.
this point in time,
And just add to the list that we've already given you the exhibits we intend to.
I want you to add the exhibits you're gonna present
I can
to
do
this particular spreadsheet. Will that suffice, Mr. Weinstein? And also, it might streamline the process, because the challenge we're having is
Right.
bless you. Counsel for the defendants are saying, this is the first time I've seen this document, or we haven't got this
Right.
document. It
Right.
hasn't been provided in discovery.
Right.
Or it's a supplementation of the original document you gave them. Maybe
Right.
They got it on that date, but instead of the document being 15 pages, it's
Exactly.
45 because it's complete. So that's why I'm saying that it causes them a little bit of
Delay.
Why did no one tell Georgia
There's-
drivers about this new rule?
exactly. I know exactly. I like the way he getting on them today before the jury come back.
Of anxiousness in terms of trying to be prepared. So
That's right.
and it'll just further validate or verify, okay, we gave you everything, and it
Right.
lessens the amount of time I got to spend resolving these particular issues. Like I said, you all are more than capable, and I'll give you the time and effort, but it needs to be better presented and packaged. So
Your Honor, we can do that, and with respect to the exhibits or evidence, I don't anticipate that we will be getting, premature objections to certain things before we had the opportunity to lay a foundation. I could foresee us saying that we're going to introduce 12 exhibits for Act 29 and the defense objecting to it as, hearsay, foundational or something before we've even had an opportunity.
well, I'm going to require them to put it in writing. I mean, so, but if you do this now, they'll be able to look at it and they'll be able to determine.
That's
A,
right.
all the university documents I need, and then 2, what are the objections? Because I can't ferret them out, and I don't think it's fair to the jury or anybody else for us to be sitting here while I do that.
That's right.
I'm not going to do it anymore. The remedy at this point in time, I think for any appellate court, I could exclude.
Excuse me, y'all. Shout out to all the teachers and the subscribers and everybody who watching. Make sure you hit the like button. I appreciate you.
And abuse of discretion is my grading mark stick. So at this point in time, if you want to make sure that you get all your evidence, at least in the sense that it is looked at or ruled upon by this court, they need to make sure that they have all of it so they can go ahead and do that. Now, if you've turned it over and it's now this period of time and they haven't filed a motion, then I'm just gonna continue at this point in time. I mean,
Got to move
Go
on.
on. We're gonna go forward.
That's right.
Because then they had the time, and you told it to them, you gave it to them. So I'm just telling you this point in time. Or, like I said, I'm
All right, state. Make sure you give it to them now.
Then we'll come in on the weekends and we'll resolve it. And I've already checked with the sheriff, and we can do that, and that will not be a problem. So I'm not looking to do that because that takes my weekend up and my time off, along with my staff and everybody else. But I have got to get this thing moving.
That too.
And we've got to be smoother and better, as advocates in order to do that. So I know that many of you may be annoyed, but hey,
It is what it is.
do better. So, Ms. Love, when can you augment this list? Can you augment it by tomorrow?
No, Your Honor.
When can you do it by? You should have a handle on it. Every piece of evidence you probably have.
We do. The court is asking for something very specific, and so our resources, we would use them to give them to the court. For instance, for next week, we could have those done for the next 2 weeks. We could have those done
By when? Tomorrow?
by.
You got to work, Miss Love.
I'm telling you, I'm
See, I'm gonna tell you what it look like. We have some amateurs for prosecutors. They're not as good as most prosecutors. She not putting all the effort that she needs to put on her witnesses on this case. She don't need to be the lead prosecutor. It's too much pressure on her. She don't need to be it. I'm sorry. I would like for her, Miss Love, to be, but she.
Not tomorrow, then that's what we do. But Your Honor, we'd ask that we not be required to
Yeah.
go through and with respect to all of the acts.
Ms. Love, you must act like I was never a trial advocate. I know you all have this stuff together already, and if you don't, I'd be highly shocked. You probably have all this stuff together already. I mean, so just put it on paper.
That's right.
And give it out so we can go ahead and go forward.
And
It is
stop
not
being
giving you a trial
selfish.
strategy. The facts are what the facts are. I'm just sorry.
She just don't want them to have
Find
it.
something funny with what I just said? Okay, all right.
I'm not doing anything abnormal. Just sitting here listening and paying attention.
Okay, all right. So, in that respect, there's nothing that should be a surprise at this point in time.
It shouldn't. See, I'm gonna tell you what Miss Love doing.
We have a motion.
Let me tell you what the prosecutor's doing. Prosecution team doing. They have everything they need to have. They so afraid to let the defendant over there know who their witnesses are. See, if they feel that, they think that if they tell them who their witnesses are, what's going to happen is they think they're going to tell their witness might change their mind and not want to talk. See, they don't want them to know who it is. Because what Miss Love trying to do is protect the witnesses from talking to the defendant. You can't hold that back, though. She got to tell them who they are. She got her work. She has it.
Friday morning by 10 o'clock. I want to see it.
She has it.
Actually, no, because you all have off on Friday. So that's why I want it Thursday now. I want it Thursday because I want to take up your motion. I told you I'd at least give you a day.
She got her work.
That's why I want it Friday morning. That's why I want it Thursday morning.
She got her work in front of her.
So I'm going to listen to your motion, the motion is qualified. I'm going to make sure the next 2 weeks of
that lady ain't done. She's smart.
You plan on calling by the 19th of April. I'm also requiring that all counsel copy myself and Mr. Kearns, Miss Weaver, and me on future correspondence going forward. Because I want to just see what is being sent to each other in turn to satisfy the court's directives.
That's right.
As to evidence. And I want it sent, piecemeal, Ms. Love. I want it sent, at this point in time, I in the future going forward, okay, I would like it to be sent, where you do the same.
The judge.
With the court's exhibit or the augmentation of your witness list, okay? I want to be able to see what witness you're calling, what act, and the evidence that goes along with it.
That's right.
Okay? All right. Any defense counsel have any comment at this point in time?
There's one simple sex mistake.
Now I like. Now, there you go, Judge. Time for you to put your feet down. I know you for the prosecution team, but
Let me cover Mr.
you got to do better yourself. And I see you trying to do better.
Anything you wish to add, disagree with about the court's instructions? So I'm looking for suggestions at this point in time. Mr. Weinstein, Ms. D. Williams, Mr. Harvey, Mr. Sharp.
I believe that you share this opinion, Your Honor, but I just want to be clear. Regarding recordings, as I've stated, there are probably thousands of recordings. I'm pretty certain Your Honor does not wish to have us, and quite honestly, I don't want to do this, go through every recording and file particularized motions for every recording and discovery.
But I'm not going to do it in front of a jury like we've been doing.
There you go.
I'm not doing that anymore.
Don't do it no more.
Okay, so what is that incumbent upon you to do then?
Well, I'm going to reiterate the fact I completely understand that you want to be forewarned about issues. I'm just going to reiterate reality that unless the plan is to have us go through thousands and thousands and write thousands and thousands of particularized motions, we do need the pared down, and I believe that's what the state's saying, but I'm just reiterating, we're going to need the pared down list ahead of time when they seek to introduce recordings so we can file in a timely manner those particularized motions for those recordings. Because to just file particularized motions for every recording and discovery would just be to cast a net that is way too wide, and it would not be time efficient for anyone.
Okay, but you all know now, even though you have thousands of recordings, you do have an idea which recordings are relevant for a particular witness or a particular period, correct?
I would not agree to that. We have,
Why not at this point in time?
well, because there's thousands of recordings.
Okay, but focus, okay? The thing I'm asking you at this point in time, if you know, for example, witness X is going to be called,
Yes.
and you pretty much know at this point in time, there may be 15 to 20 recordings that are relative to that particular witness. Are you telling me that you true or not true? Is that?
No, I don't believe that's true.
Why would you say that's not true then?
Because that's why I'm saying in a timely manner, and I'm not even suggesting that the state hasn't done this. I'm just trying to bring this to the court's attention, and if we need those specific recordings that the state plans to use be identified to narrow the net, then we can file our particularized motions in a timely manner.
So unless the state identifies them, you haven't looked at them in terms of that particular time period, of that particular witness's recordings?
As Your Honor has pointed out, this is a RICO conspiracy. There's thousands of calls, and I can't believe, I don't believe that Your Honor is saying this, but there's hearsay.
I'm sorry?
There's hearsay.
Uh-huh.
There's inadmissible, there's third-party statements on every single jail call. And I'm certain that the expectation is not that we file motions on every single call in discovery. And Your Honor, I do not know what calls the state finds particularly relevant versus calls they don't. They're putting on a case, and I cannot forecast their case. Yes, my client, for instance, Ms. Hilton sent me 5 calls in particular regarding my client's calls. And out of thousands, probably hundreds. And I am fully aware of those calls, and I'm not going to dispute that I'm on notice of those calls. All I'm stressing to Your Honor for the smooth administration is, to the extent the state has, that it continues, to the extent that they haven't, that it begins identifying in advance what calls they anticipate using to at least narrow it down so we can focus on the meat of this case instead of calls that they never plan on using.
I hold that thought.
Yes.
Here's the challenge, Ms. Lowe. Mr. Sharp brings up a good point. Say Ms. Hilton gives the 5 calls, but instead of 5 calls on the morning, it's 8 calls. And they haven't identified or listened to those other 3 calls. That's what I got to take up, and that's what usually causes the issue.
We've not done that, Judge.
No, I'm gonna disagree because that's
Y'all done did that a lot.
But that's all I'm saying. Mr. Sharp, do you have anything else? So you want them to keep identifying the calls and whatever recordings they wish to do?
That is correct.
Okay.
Thank you.
All right. Okay. All right, Mr. Adams or Mr. Steele? Okay. All right. All right, Mr. Weinstein? Anything else?
Thank you very much.
All right. So,
There's a big government scandal going on that you need to know about it.
Judge on the judge getting tired of their BS. I'm sorry, y'all. Judge getting tired of them. But it makes sense what they saying though. I love y'all. Let me get this light off.
all right, and defense counsel. This is, I mean, I know that there's 8 terabytes worth of stuff, okay? But that in no way alleviates your responsibilities to, to listen to as much or to be prepared as much as you can. This should kind of help out in the sense of everybody kind of knows where they are, should be, at least where we're presenting or witnesses. Does anybody have any questions or issues with with the witnesses that the state has identified. I know that they have identified the accident and
Yeah.
Mr. Sharp.
I would just like to forecast one issue, and I think we need to talk about this at some point before it comes up. I see that it's not scheduled until May, but witness 89, Sammy Davis. I noticed he is on the witness list. He alleges that he was at the scene at the time of the Donovan Thomas shooting. Your Honor has suppressed out-of-court identifications. I do not anticipate that he will make any in-court identifications, but I would like to have a conversation before he testifies with the court about the proposed testimony and what Your Honor would consider fair game without opening any doors by the defense to violate or to put in jeopardy your prior ruling. I think that there needs to be a discussion outside the presence of the jury.
When did I make that ruling?
I do not have the order.
Do you have a copy of the order? Well, send that to Mr. Kearns, and I can take a look at it.
Yes, Your Honor.
I sent it to everybody, but you sent it to include Mr. Kearns and myself. Going forward, like I said, please include me on your correspondence so I can go ahead and at least be apprised of what is being sent or communicated between all parties, so I can be better informed. All right. Other than Mr. Davis. All right. Does anybody else have any other information or issues they need to bring to the court in terms of the witnesses that have been identified? We're going to add the documents that are to be called. What I'll do is, as long as they need to provide those by Thursday morning, and then the next.
That's tomorrow morning.
Tomorrow, yes, ma'am.
Y'all got to get to working. You're getting paid for it. They ain't gonna do right. Somebody ain't gonna do right. They ain't gonna do right.
I'll just indicate in my order that every 2 weeks the witnesses as well as the evidence list will be reprinted, or I should say will be disclosed for the next 2-week trial period.
Your Honor, as
Sir.
As to whether any of us have any other issues with the witness list, just speaking for myself, as we just received the list 15 minutes before the 11 o'clock start time today, and I in no way mean to say anything negative about the state. I'm sure they stayed up quite late putting this together, if not all night. But I'm going to need more time to look over this list to see if I have any issues.
All right.
Judge, this list is comprised of people with the exception of the ones that I named that
4 or 5 that you've identified as the same list has been provided.
these names have been provided for months and months and months and months, maybe even a year. So if there are objections to these people, I would have.
Well, just get with them.
Expected that those objections would have been raised before now with respect to anybody on this list, because this list is a pared down version of the list that Your Honor has.
Well, Miss Love, it's some people they haven't had.
And Your Honor, I'm not going to, although I have looked at this, I'm not going to disagree that this list includes names or comprises names that have already been provided to us. I'll take the state's representation on that. All I'm saying is as far as any of these witnesses being a waste of time or cumulative, I need to really look at this list before I raise any issues with respect to that.
And Your Honor, with respect to the defendant's,
She loved to argue.
about wastes of time and cumulativeness
Knowing that camera
of
right there.
witnesses, I know that the court is aware.
Every Medicare recipient over
She-
65 years old needs to see
She
this.
know that
The
that
government just gave me
camera is right
thousands of
there.
dollars.
And I'm certain counsel for the defendants are aware that the state alone has the burden, cannot. The court has control over the order and presentation of the evidence, but I would think it quite presumptuous for a defendant to be able to assert to the court, when I'm certain he'll argue in the end, they didn't bring you this, they bring you that, or there wasn't enough evidence. I would find it quite presumptuous to argue that, or presume themselves able to tell the state that a witness is cumulative or unnecessary when they will be quick to say and point out the fact of the matter.
Come on, calm down, Miss Love.
We do, and we intend to meet that burden. And they are not able to, I would think, suggest to the court their best version, because I'm sure it would be much less than ours, of what witnesses we need to put up to prove what. And
No.
if we have 2 or 3 witnesses that testify about the same set of events, but from various vantage points, in no way could that be considered cumulative when, again, we have the burden of proof. And
What is she talking about?
What's enough, I am quite certain will never equate to what I believe may be enough.
Well, I'll make that decision on a case-by-case basis, so,
She just argue about nothing.
responsibility, so I'll take it up as it's
Jesus.
presented. Okay.
Fussy.
All right, anything else?
Just fussy.
Ms. Love, by 5 today, please submit a response so I can read it before tomorrow morning.
Yes, Your Honor.
All right, anything else on the witness list or anything? So we'll update the witness and evidence list. Mr. Kearns and I will work on an administrative order. And I will endeavor to enter that tomorrow. And so my goal for tomorrow is just for us to take up this motion to disqualify, and that's it. I don't think I have anything else. Is there anything else I missed? Councilors? Yes, Mr. Steele.
Good afternoon, or good morning. Good afternoon.
All right, sir.
Your Honor, there is a matter that we'd like to take up with this honorable court, ex parte on a sealed record at the appropriate time today, if you don't mind.
Okay. All right. Okay, I'll take that up as soon as we're finished. Okay. All right. Anything else, councils? Other than the ex parte matter? All right. If not, I will see everybody tomorrow morning, the 4th of April, for 9 o'clock. Okay.
Okay, y'all. You all have watched the Strictly Witnesses and what they're going to provide for us the next time, since the jury is on a vacation. They're on spring break. So this was day 53. Only thing they settled down is not to do certain things in front of the jury. And another thing, make sure they go over the witness sheet together, I guess so, God. I hope y'all enjoyed. I've been sticking with this trial. I'm gonna stick with it. Long as Young Thug in it. Y'all like, share, and subscribe. I'm out.